welcome to the Planning Commission meeting here on November 17th. Is there a motion to approve the agenda?
I move to approve the.
And a second?
Second.
Call the roll?
Commissioner Newton,
Yes.
Commissioner Patrick. We never got Janet, did we?
No, I haven't seen her show up in the list now.
Okay. Commissioner Burt,
Here.
Commissioner Bennett,
Yes.
Commissioner Kerr. Kerr, Commissioner Kerr. Oh, we can't hear her, Lisa.
Oh, Lisa's muted. Okay, hold on a second. Okay, now we should be able to.
Yes.
Yes.
Thank you, Lisa. Commissioner Dodd,
Yes.
Chair Johnson.
Yes. And do I have any amendments to the minutes? Okay, if there are no amendments to the minutes, do I have?
I got one.
Bill was,
I just unmuted.
Yeah.
Bill.
go ahead, Bill.
All right, there we go.
Yeah, there we go. All right, and Jeff, I sent you an email about this earlier about the minutes, that there is something I'm looking for in minutes now. I can't seem to locate them. But there is, I believe it's at the bottom of page 3. There is language that, what could I, oh, here's, that says, we talked about the particular, hang on a second, let me find this because I thought.
I've got it, Bill. I've got it.
Okay, thanks.
It's on page 7 of 12, page 10 of the 23 in the PDF. It says Kabizman gave an overview of the oceanfront setback and the subjective laden value standards. I don't think that accurately reflects what I actually said. This is from Bill. I would ask that the sentence be corrected to read as follows. Kabizman gave an overview of the oceanfront setback and how it does not involve subjective value laden standards. End quote.
Okay, is that it?
Yeah.
That's it.
Okay, no other corrections? All right, do I have a motion to approve the minutes as changed?
I so move.
Is there a second?
I'll second.
Okay, call the roll.
Commissioner Patrick. Oh, sorry. She's on the front. Commissioner Burt,
Yes.
Commissioner Bennett,
Yes.
Commissioner Kerr,
Yes.
Commissioner Knopf,
Yes.
Commissioner Newton,
Yes.
and Chair Johnson.
Yes. This is a quasi judicial hearing regarding the continuation of AA 20-02, 3 and 4, appeal by Stanley and Rebecca Roberts of an administrative decision to approve with conditions and development permit DB 20-04. AA 20-02, 3 and 4, Stanley and Rebecca Roberts appeals of the city's administrative decision to approve the conditions, a development permit, DB 20-04 of tax lot 51031 AA 00600. The applicants have filed multiple appeals of the same decision challenging the city's application of a oceanfront setback under section 17.42.050A6. including challenging the condition of approval regarding the performance of the performance of an oceanfront setback survey and compliance with the same, to obtaining a setback reduction pursuant of Chapter 17.64 of the Municipal Code to accommodate the setting of a new single residential residence. The property is vacated lot located north of Neana Avenue, tax lot 600, map 51031AA, and in a residential low-density zone. The appeal will be reviewed pursuant to Municipal Code Section 15.04.150 and Section 17.88.180, review consisting of additional evidence or de novo review and application section of the zoning ordinance. Does anyone object to the jurisdiction of the Planning Commission to hear this matter at this time? Does any commissioner member believe he or she has a conflict of interest or personal bias? Has any commissioner member had an ex parte contact or made a site visit?
Site visit.
Site visit.
Site visit.
Site visit. Okay, staff report.
I'll start, Bill. I just wanted to clarify that I recognize we have a lot of new materials that have been added. We try to put as much as we could in entire packet up on the website, exhibit by exhibit, and that's attached also or linked to the Planning Commission web pages for each of the meetings so that you could find those materials. Hopefully everyone has those and has reviewed those. And then I just wanted to say, I know there's a lot of materials in the record, but simply for, at least from the staff perspective and the one that made the decision, it boiled down to, was this an oceanfront lot? And was this an oceanfront setback? And that's what drove the decision. And so I'll let Bill clarify the rest of the staff report. I have added the addendum that hopefully responded or clarified to some of Mr. Raskin's comments at the previous meeting, but that's basically all I wanted to say.
Okay, thanks, Jeff and Chair Johnson, commissioners. I'm going to give you a brief staff report. I'll try to focus. First, thanks for your flexibility tonight about the venue and everybody getting online. Look forward to getting back to in-person meetings, but for now, the city and the state has made it clear that this is the appropriate way to go, and so we're going to stay electronic for a bit. For the staff review, I want to give you a brief procedural overview where we are now, talk briefly about what's come in, then a quick summary of where we are and what the commission should consider this evening. As you recall, and as Chair Johnson indicated, we're here tonight to hear 3 appeals from the city staff's issuance of a development permit. They all challenge the same development permit. They all raise the same issues, but only one of them was properly filed. The other 2 were pursuant to different provisions in the code. I wouldn't worry about that too much. We can sort that out in the findings. I wouldn't focus on that as part of your deliberations tonight. So where are we procedurally? As you recall, the Planning Commission held an open hearing on this matter at your October 22nd meeting. At that meeting, you took all the testimony and evidence anybody wanted to provide and left the record open for 3 periods. Those open record periods have closed, and all that material, as Jeff has indicated, has come in and is available at the links. At this hearing, there shouldn't be any new evidence, or instead, everything should be limited to argument. Any person can argue for 5 minutes, with the applicant getting a final 5-minute rebuttal section. As Jeff indicated during the open record period, there's a lot of new information arguments that came in. Some were over 50 new exhibits on Jeff's list. Most of the exhibits were really about the same issues that were discussed last month at the hearing. And I don't plan to summarize all the new evidence or testimony, but if you have a question about a particular submission or a particular topic, Jeff and I will be happy to assist you either before we go to the final arguments or after we get through the final arguments. So what's the commission doing here tonight? Although there's a lot of evidence and argument, the basic question is pretty straightforward, as Jeff indicated. Does the applicant's proposed house comply with the oceanfront setback line? but there are issues raised about every subpart and issues raised about why it does not apply and a few other issues outside of the oceanfront setback. I'll note that regardless of this commission's decision, it's likely that someone will not be happy with whatever you make and may well appeal it. I say that largely to suggest that I wouldn't look for a way to make everybody happy. Instead, focus on the criteria at issue, whether or not the arguments that are made and whether or not this proposal meets that criteria. As Jeff indicated, the key one is the oceanfront setback. There's several parts of that setback, but the general intent is to require an applicant to set back any new structure by an amount equal to the average setback of other adjacent or nearby structures along the oceanfront. The applicants do not dispute that their proposed house does not meet the oceanfront setback as it's calculated by the city, but they raise a number of other issues. The argument include that that the oceanfront setback was calculated incorrectly. The lot is not oceanfront; it's separated by Ocean Avenue. There are no adjacent structures. The adjoining property is not oceanfront. The average of adjacent structures should include unbuilt properties. The oceanfront setback is not clear and objective. The oceanfront setbacks improperly requires reduction in density. Denial of the application for not complying with the oceanfront setback will be a taking of their property. Some of the opponents also raised a number of new issues in the written material, mostly centered on other standards from the oceanfront management overlay zone. After reviewing all the various arguments in the new submissions, the staff's recommendation to the Planning Commission remains the same. The commission should deny the application, affirm the planning director's decision for this particular application failing to meet the oceanfront setback. With that, Jeff and I are available to answer any questions or discuss any topics. Otherwise, the Planning Commission can move on to the public hearing, or the final arguments from the parties.
Question. Bill?
Yeah.
So in this meeting, we can't consider the safety issues or the traffic issues proposed or the geological hazard issues at all?
So the opponents have raised those issues as part of the oceanfront overlay zone. In looking at those, Jeff and I believe that those are not implicated by this particular application. Some of these come up with perhaps the application when they go to build the access to their property. But at this point, we don't think there is, obviously the applicant, or not the applicant, some of the neighbors have raised that issue. And if you believe that those other criteria apply, then you have the authority to disagree with what Jeff and I are telling you if the Planning Commission wants to go there.
Okay.
I'd like to add to Lisa's question, and that is, I'm sort of amazed that this ever was approved in any form without having gone to the Planning Commission, because it raises so many issues that various opponents raised that we probably should have been looking at in the first place. Just a point of view.
And that may be something you want to look at amending your code in the future.
No, I don't think it's a matter of amending the code, Bill.
Okay.
Okay, are there any other questions for Bill? Okay. The pertinent criteria to be considered are noted in the staff report and listed on my criteria sheet in the meeting next to the, the pertinent criteria to be considered and noted in the staff report and listed on the criteria sheet in the meeting page of the city's website. Testimony, argument, evidence must be directed towards those criteria or other criteria in the comprehensive plan or municipal code when the person testifying believes to apply to decision. Failure to raise an issue accompanied by a statement or evidence sufficient to afford the decision makers and the parties an opportunity to respond to the issue precludes the appeal based on that issue. Prior to the conclusion of the initial evidentiary hearing, any participant may request an opportunity to present additional testimony, argument, and evidence regarding the application. The Planning Commission shall grant such a request by continuing the public hearing and leaving the record open for additional written testimony, arguments, and evidence. Persons who testify should receive recognition from the chair and state their full name and mailing address. And if representing, identify who they represent. Is there a presentation by applicant?
That should be Wendy.
So we want to unmute.
Yeah.
Okay.
And you might mention the 5 minutes.
Yeah. Is there a presentation by the applicant?
Yes, there is, Mr. Chair.
Okay, and keep in mind that you've got 5 minutes. So would you identify yourself?
Yes. Wendy Killington representing Stan and Rebecca Roberts. The Roberts very much look forward to joining the Cannon Beach community to build their home on their residentially zoned lot where a previous house stood for 50 years. This is to request that you approve their application as submitted. With the greatest of respect, there is no legitimate reason not to do so. Their home meets all standards when those standards are properly applied, including the ocean setback. As we have explained, the ocean setback contemplates at least 2 structures to come up with an average. When there is only one structure, like we have here, you either default to the 15-foot minimum ocean setback or you average the default 15-foot setback and the one other structure. In either case, the Roberts application meets the ocean setback when it is applied as it is written. None of the other standards that opponents complain about apply under the express terms of the city's code, as your staff has told you. The Roberts property is not on any kind of dune. It is permitted residential development. The active landslide that it and a dozen or more homes in South Hemlock sit upon has been stabilized, and the evidence in the record is unequivocal that the Roberts home will stabilize it further. There are no wetlands, and their application meets all city tree standards, removing just 6 trees, 2 pines, and 4 alders, one of which is already dead. There is simply no basis to deny the Roberts application. On the other hand, state law compels approval. To the extent that the city is inclined to deny the Roberts proposed home, state law prohibits the city from doing so. And this is for good reason. As a matter of sound land use policy, it is not in the public's interest to foreclose residential development on land the city has zoned for residential use, because that is by definition the formula that causes urban sprawl. City leaders have wisely decided that the lots in the Roberts residential subdivision will deliver housing to the city's citizens. The Roberts proposal is reasonable. It is less than the maximum 3,000 square feet of floor area the city code allows. It will greatly exceed the default 15-foot ocean setback. In fact, the Roberts home will be set back 87 feet if the point to beginning is the statutory vegetation line, which will be one of the largest ocean setback distances in all of the city. Certainly, it is no basis to deny this family the right to build their home on their residential lot, because some people don't like the looks of the public street improvements required by modern city standards. The Roberts, just like everyone else, have a right of access to the abutting street right-of-way. They cannot be denied their right to build their home simply because they're willing to improve the public street, not a private street, a public street, to current city public street standards. The demand by some that the Roberts only be allowed to build between a 600 and 1,300 square foot home is unreasonable and not supported by the city's code, state law, or federal law. The evidence shows, in fact, that no one has built a new house in Cannon Beach in the last 30 years that was less than 2,000 square feet. The structure the Roberts wish to call home, although significantly smaller than their opponent neighbor's 4,180 square foot house to the north, is just right for their retirement, a proposed 2,712 square foot home in the peace and tranquility of Cannon Beach that they love. The Roberts' proposed home will be another house stood until the 1980s. It will be served by the same right-of-way that served the previous home. The Roberts have earned the city's approval, and accordingly, they respectfully request that you approve their home. Thank you for your consideration.
Thank you. Are there presentations by proponents?
I think, Wendy, didn't you say Jay Raskin was also going to speak? Yeah, there's Jay.
Jay?
Yes.
Oh, you can proceed, but you can't proceed over 5 minutes.
Okay, I'll keep it below 5 minutes. I wanted to confirm that the Roberts lot is a corner lot and that its proposed house meets the setbacks in the city code. 5 feet, a 5-foot side yard to the north, a 5-foot rear yard to the east, 15-foot front yard to the south on the Nana. And it was also my understanding when I was designing it that the ocean shore setback didn't apply in this case since it abutted Ocean Street. This was based on my reading of the statute, and it was also based on several projects I did of renovation addition projects on Ocean Avenue in the presidential streets, where we had 15-foot setbacks and we were not required to do oceanfront averaging. The second point I'd like to address is that staff has taken issue. Excuse me. Staff has taken issue with my statement that we needed 3 feet of the building footprint in order to provide parking spaces, which require 18-foot depths, stating that parking can be provided in the ocean yard west of the house at grade. Staff did not indicate how we would be able to get from the roadway down to the grade, a drop of over 12 feet, and then be able to turn around and come back up. It is mistaken that parking can be provided other than is shown in the plans for the Roberts house. Parking as proposed meets all city standards and is required and is what is required for this home, given the grades of the property and the requirements to the budding right-of-way. Providing required parking has to be part of the structure. Thank you.
Thank you. Are there other presentations by proponents? If not, are there presentations by opponents?
And that could be your list there. Bob Lundy, I think.
Yeah, should we just go?
Yeah, I think so.
Bob Lundy, do you want to make a presentation?
I am muted now. I seem to be. Okay. I'm gonna take my, oh dear. I'm hearing an echo of myself. Is there a way I can get rid of that, or do I just have to live with it?
We're not hearing an echo, Bob.
Okay, let's see if I can read this through the echo. It's pretty short. First, as you will have seen, Jeff Adams' staff report is comprehensive and articulate, addressing all of the real and potential issues. This is the staff report from the October 22nd meeting. I think you should act as he recommends in the conclusion of that report on page 15. This is, I don't remember what it's 15 of. So, second, and least, looking at the composite illustration of the proposed house as submitted by the applicants as figure 15 on page 242 of the packet, it is clear that they envision it as a beachfront house with no buildable lot in front of it. Third, the aerial photos and diagrams submitted by the applicants show that the proposed house, Exhibit 5, page 143 of the packet and elsewhere, will be closer to the shore than the earlier one, which they report was destroyed by a landslide, pointed out with a red arrow in figure 9 on page 239, rather than occupying the same footprint. Fourth, it would be irresponsible of the city to approve the building of a house on, as the applicants assert, or just below the site of the one that has been destroyed by a landslide in an area well known to be geologically active. Thank you for your attention.
Thanks. Okay, there's some other folks on the list of opponents. I assume that they would like to speak.
Yes, Susan Glarum.
Susan, are you there?
I am here.
All right. You may continue.
Okay, I'm speaking on behalf of myself and Daryl Kluke, P.O. Box 108, Cannon Beach, Oregon, 97110. The issue of whether or not the oceanfront setback rule should apply to the proposed building project in front of Haystack Rock by Stanley and Rebecca Roberts is what I would like to address here. This rule has been applied to all oceanfront properties since the 1990s. The purpose is to ensure that all oceanfront homes are approximately the same distance from the beach, thus preserving the views of the neighbors. Perhaps even more important, protecting those properties from the effects of erosion due to large storm surges, king tides, etc. We all know that because of climate change, storms are becoming more powerful, leading to potentially more serious erosion effects. When the Roberts purchased their property, they were fully aware of the ocean setback rule, and to argue now that it shouldn't apply to them is not right. Their contention that the application of this rule would impose unreasonable cost or delay is not valid. They are perfectly able to build on their property by altering the footprint of their proposed house to be within the allowed buildable area of the lot. It is also not right that their proposed building would obstruct the view of the neighboring Oswald West home. The oceanfront setback rule was put into place to prevent just such an occurrence. I believe the city erred in granting the Roberts conditional approval of their application prior to receiving all the required plans for the project, including site plans and tree removal applications. No public notice has been given regarding the removal of those trees. This is required by CBMC 17.70.030. In addition, this property is in an area of unstable slide-prone ground. Tree removal and the building of the house and driveway could increase the risk of such land movement. The Roberts also should be required to comply with federal and state laws regarding the preservation or mitigation of the wetlands their proposed driveway would cross. My final conclusion is to ask you, the Planning Commission members, to deny the Roberts challenge to the application of the ocean setback rule and deny their proposal outright. Thank you.
Thank you. Okay.
All right, next we have John Newport.
John, are you there?
Can you hear me now? I was trying to unmute myself.
Oh, okay.
All right. This is John Newport. Mailing address is 111 Southwest 5th Avenue, Suite 3400, Portland, Oregon. I am going to address the arguments made by the applicant at A-42, pages 15 through 21, which is their November submission, where they make an argument that Ocean Avenue is a buildable lot, and therefore the ocean setback rule doesn't apply. The applicant makes that claim based on a statute adopted in 2019, ORS 197.779, and they claim, and I quote, Ocean Avenue is now a buildable unit of land that is available for residential development. That's at A42 at page 18. That argument's wrong for at least 3 reasons. First, the statute by its terms applies only to, quote, real property of the state, counties, and cities, close quote. Ocean Avenue does not fit within the definition because there is no basis to claim that the city owns Ocean Avenue. The plat dedicates to the public for use as thoroughfares forever the streets and avenues noted on the plat. That's forever. The dedication of that land for public use as streets is not a grant of ownership to the city. And that plat was recorded in 1908, more than 40 years before the city was founded in 1953. The dedication for a thoroughfare is not a dedication for housing. If the city tried to change the dedicated purpose, the public and successors of the grantor could sue the city to prevent the conversion. Remember, Haystack Rock LLC abuts Nenana, and we have a property interest in seeing that Nenana is used only as a thoroughfare forever, not as a private driveway. Second, even if ORS 197.779 applied, it only removes, quote, any land use regulation, comprehensive plan, or statewide land use planning goal, close quote, that restricts housing. It does not and cannot remove the restrictions that the grantor placed when it dedicated the property to the public forever as use as a thoroughfare. And third, Ocean Avenue is the beach. Housing cannot be built on it because of the Oceanfront Setback rule, the Oregon Beach Bill, and other state laws that prevent building on the beach. And interestingly enough, if you look at the 1908 plat, which is at CO2A Exhibit 13, it shows that the access to the applicant's Lot 13 was intended to be from Ocean Avenue. When you look at the plat, it has Ocean Avenue to the west and it has Atlantic Avenue to the east. I've been unable to locate any existing Atlantic Avenue, and therefore the intended access to this lot was to be Ocean Avenue. And if you look at our submission, which is D15 at page 92, there is a photograph showing access to Lot 13 in July 1913 from Ocean Avenue. Ocean Avenue is not a buildable lot, and therefore the ocean setback rule applies. We are not asking for special treatment. We just ask that the city apply its ocean setback rule to the Roberts as written and as applied to oceanfront property as this is and has been applied to oceanfront property for many, many years. The city should apply its rules and deny this application. Thank you for your time.
Thank you.
All right, Kevin Newport is the next one.
Can you hear me?
Yes.
Excellent. My name's Kevin Newport. My address is 4332 Southwest Semler Way, Portland, Oregon, 97221. We have been good, longtime stewards of the historic Oswald West cabin, and we oppose this proposal because it violates the rules that everyone else in town follows. Point one, we have been good neighbors to the city in supporting the public projects, and we are not okay with that being used against us. We continue to support the city's Inspiration Point efforts. We have made a proposal to buy the Roberts parcel for what they paid for it. If the Roberts sell us the property, we would entertain the idea of adding it to Inspiration Point and vacating Nanana to further expand Inspiration Point. That would resolve this whole situation. Part B. We've supported the city's dewatering project, even though we've never had movement of the cabin, as shown on the city's landslide maps. We are not okay with our help on the dewatering project being used against us. I saw in Don Rodman's latest submittal that the pipes should be cleaned and maintained annually. In his June 6th submittal, Mr. Rodman noted that annual maintenance of the drains is required to maintain the current S-curves conditions. He noted that one of the pipes is already fully blocked and that some of the pipes may be partially blocked as part of the Roberts proposal. 3 of these pipes run under our property, Oswald West Cabin. The city easement for those pipes expired a few years ago. The Roberts have no right to maintain any of these pipes that they rely on for stability. Part C. Stripping the hillside or the landslide and replacing it with a house in the oceanfront setback and a road, bridge, ski jump 25 feet on pilings in the air is not the city of Cannon Beach. The city must apply its oceanfront setback rules and deny the proposal. Thank you for the opportunity to speak.
Thank you.
All right, next is Jan Siebert-Warman.
Let's see here.
Which should be 1, 2, 3 at the end there.
Yep. So it's unmute.
Jan, are you there?
It hasn't unmuted yet.
Jan, please unmute your phone there.
Yes, can you hear me now?
Yes, thanks, Jan.
Thank you. I'm Jan Siebert-Warmond. I'm reading 2 brief letters tonight. The first letter is from the Ecola Creek Awareness Project, ECAP, from our board of directors, of which I am a member. ECAP's address is P.O. Box 181, Cannon Beach, Oregon, 97110. To the Cannon Beach Planning Commission. From the ridgetops to the ocean, the health and safety of our community's watershed is the continuing responsibility of the residents, workers, and visitors of Cannon Beach. The Ecola Creek Awareness Project, ECAP, is a local nonprofit organization whose primary purposes are to foster stewardship and understanding of our local watershed resources, address natural resource issues, and promote sustainable watershed health, functions, and uses. This letter is to voice our concern regarding the proposed new house of Stanley and Rebecca Roberts and its lack of compliance with the city's oceanfront setback requirements. Based on this lack of compliance, ECAP respectfully requests that the Planning Commission deny the Roberts appeal. We thank you for your consideration of this serious matter. The second letter I'm reading tonight is a personal letter from my husband, Wes Warmond, and myself, Jan Siebert Warmond. Our address is P.O. Box 778, Cannon Beach, Oregon 97110. Dear Cannon Beach Planning Commissioners, we have lived full-time in Cannon Beach since 1988, doing our best to promote our community and its environment, to protect our community and its environment. It is our understanding that the city has received information from the Roberts in the form of a survey which showed that their proposed new dwelling does not comply with the Cannon Beach oceanfront setback requirements. Because the Roberts proposed new dwelling doesn't meet our Cannon Beach standards, we urge you, the Cannon Beach Planning Commissioners, to deny the Roberts appeal and to support the Cannon Beach Community Development Director's decision addressing this case. The livability of our community depends on each of us doing our part to respect and follow the reasonable, meaningful rules and regulations we all share. Thank you.
Thank you.
All right, the next is Will Rasmussen.
Will?
I can unmute. There you go.
There you go. Can you hear me?
Yes.
Good. Hi. I'm Will Rasmussen from Miller Nash Graham and Dunn. Address is 111 Southwest 5th Avenue, Suite 3400, Portland, Oregon 97204. I'm speaking again on behalf of Haystack Rock LLC, the owners of the historic Wild West cabin. I'm just going to touch on two issues today in summary. One, as I mentioned last time, why this is in fact an easy substantive decision for the city to apply the oceanfront setback here. And then two, I'm going to touch briefly on the safety issue at play in this case and why it matters and where it exists. On the easy substantive decision, the city should apply its oceanfront setback. It's a relatively straightforward standard. The staff report provided about 20 pages walking through each component of it, explaining how you take a line and you go through a mathematical equation to get a new line. That's about as clear and objective as you get under the Oregon system. Applicant argues that it's capable of two interpretations, and that makes it not clear and objective. That's just simply not the standard that LUBA and the Oregon Court of Appeals has articulated for whether a standard is clear and objective. Just about any city code provision I have ever seen, you can come up with multiple interpretations of it. Even the most straightforward code provisions like a height standard, 28 feet height, or a setback standard of 5 feet can be interpreted a bunch of different ways. For example, on height, where do you measure that height from? If you're on a slope, do you do the top of the slope, the bottom of the slope, or somewhere in the middle of the slope? If you have a pitched roof, do you measure to the top of the roof? Or as this commission has recently considered, do you measure to the top of a precipice on top of the roof or a turret on top of the roof? These are objectively clear and objective standards under LUBA's threshold. And the question on whether it's clear and objective is whether it's applicable to subjective value-laden standards. And the oceanfront setback is about as far from subjective value-laden standards as you have. As I mentioned last time, just some examples of phrases that LUBA has found are clear and objective. A foredune. What's a foredune? Now, LUBA says that's close enough to be clear and objective. Is a slope relatively flat? Again, you don't need a precise percentage like we have here. We have a precise number of feet at play here, but the idea of a standard that is a slope relatively flat, LUBA is found to be clear and objective. It's a relatively easy, straightforward decision. Applicant has submitted in its most recent submittal 40 pages for you, arguing that it's not, and arguing that the city has no choice but to ignore its oceanfront setback standard. That's just not the case. And certainly if applicant chose to appeal this up to LUBA or into any other jurisdiction, I would recommend to my client that we participate and just walk through the legal, kind of the legal explanation on why what the city does in applying its oceanfront setback is perfectly normal and perfectly legal, as it has done for decades now. The second issue I said I wanted to touch on is the safety issue at play in this case. And I want to just take a second on why with the Planning Commission, why I talk about this. The city says just apply the standards as it is, it's clear and objective, and that's the final answer. And they're right. That is the final answer. I will argue here and argue if this goes up on appeal that there's a very important safety issue at play here. And that matters because if for some reason LUBA decided that it wanted to follow any of applicants' theories regarding clear and objectivity and needed housing and whatnot, cities can apply non-clear and objective standards to address safety issues. And there's clearly some major safety issues at play here regarding the active landslide, regarding the proximity to the coast. One of the members of the public talked about how global warming is increasing the rate of erosion, the severity of storms at play here. And that is both relevant for the ocean shore setback, and it's relevant for chapter 17.50, the geotechnical hazards section that's at play in this case, and it's talked about in the record. I just want to remind the Planning Commission that one of the purposes of the ocean shore overlay, chapter 17.42, is to, quote, reduce the hazards to property and human life resulting from natural events and development activities. Here, we're on an active landslide. Here, we're abutting the coast. That's something that's very much at play in this case. And applicants' own reports talk about how the stability of this site is reliant on the dewatering pipes that the city's put in for Hemlock, that my clients have helped the city put in under Hemlock. And those same reports, as you would expect, say the functioning, the functionality of dewatering the site, which provides stability to the Hemlock S-curves and the surrounding areas, relies on those pipes being maintained each year. Applicant has no right to maintain those pipes. Oh, is that 5 minutes?
Yeah, I know it's close to it.
Okay, well,
Okay.
I'll wrap up.
Okay.
There's clearly a safety issue at play here, and I will continue to argue that that's relevant, as well as to the fact that this application just doesn't meet the standard. Thanks for the opportunity.
Thank you.
That's all that we have for public comment.
Okay. Does the applicant wish to make an additional statement?
Wendy?
Yeah. There we go.
Go.
Hello?
Yes, hello, thank you. Wendy Kellington for the applicants. First of all, in the record, it is clear that the Roberts home provides no sightline impairment to anyone. Number two, I think we found something we agree upon with the Newperts, and that is both the Newperts and we have a property interest in the use of Nenana as a public right-of-way. That's a property right, and the Roberts have it just as the Newperts have that. The ocean setback 3 can be applied and should be applied the way the city's code authorizes it to be applied, and that is to take an average of the only structure within 200 feet, and then to take the default 15-foot setback to the south, average them together, because what you will get is still an ocean setback that greatly exceeds almost any other ocean setbacks that the city has dealt with. Right now, the Roberts dwelling is set back 87 feet. That's a huge amount. Nobody's talking about bending the rules or not applying the setback if you apply it the way it's written. If you do not apply it the way it's written, then state law does not allow it to be applied. And the opponents, of course, will tell you that they feel real good about going to LUBA on the city standards being clear and objective. But the very standard that opponents' attorney cited for you, height, is the one that the Court of Appeals and LUBA have both decided is not clear and objective, exactly as Mr. Rasmussen described. So the threshold for clear and objective standards is pretty high. And the reason for that is that it needs to be easy in Oregon to cite housing. Oregon is serious about citing housing. And I believe that the city's standard won't pass. Fourth, the opponents badly misquote and mischaracterize Don Rondema's report. So let me tell you what they really say in the record. Don Rondema has said that the dewatering system that the city has is composed of some 15 to 17 different pipes, of which only 3 are on the Newport's property. Many of them are on other properties of which our clients and others have graciously worked with the city and given the city unlimited easements and unlimited access to maintain those pipes. It's only the Newports that have put a limit on it, and it's only the Newports who are refusing to work with the city on those pipes. But what Don Rondema says is that the pipes that underlie the Roberts proposed home and the improvement of the right-of-way will not be impaired by the proposed home. That's what the record says. And he also says that regardless of whether the Newports choose to continue to allow the city to use the Newport property for 3 pipes, that the city's dewatering system will continue to work. And you can ask your staff about that because that's what the record clearly shows. In some, and the last thing, the Newports had not agreed to purchase the Roberts property for what they paid for it by a long shot, or what they have into it by a long shot. The statement is pretty insulting, but that's really not the point, is it? The point is that the Roberts own property in a residential subdivision zoned for residential use. The state and the city have set that land aside to be used for residential purposes. And the opponents are asking you not to allow them to do that for their own particular reasons, but they don't have anything to do with the city's policy and the state's policy of delivering housing using this lot. The Roberts deserve a chance, they've earned a chance to become a part of this community, and we ask that you approve their home proposal. Thank you.
Okay, thank you. That's all. That's it. Okay. In that case, we are going to close the public hearing and move on to consideration. I would just like to say that there's hardly anything in this proposal that I like. And I think all the arguments that the public has made and the representatives have stated the hazards in this area. So that's my stand on this. I'd like to hear from the other commissioners.
Well, I think I could look at both arguments and find things I liked and didn't like in each one of them. But what I've really tried to do when considering this, and especially knowing that whatever our decision is, and Jeff, I think you said this at the beginning, whatever our decision is, it's probably going to be appealed. It very reasonably could be appealed to a higher board. So I think it's important just to stick to the things that we feel most certain about, that we have the most clarity on. Otherwise, we're just adding more uncertainty and more issues to an already laden file. So I would really encourage us to focus on what's really clear and what we feel really strongly, or feel like we have a very clear and concise understanding of.
Am I muted?
Yes, no, you're fine.
Oh, okay. I'd like to move that we deny this application. I would deny it for the following reasons. I think that the standards for the oceanfront setbacks are clear and objective, and the city applied them in a clear and objective manner. The applicant cites statutes and ordinances that are not even relevant to this application and takes them out of context. the oceanfront setback should be applied in this case. I also take issue with the applicants when they talk about the need for housing. I think they're misconstruing what is being referred to. It is not a need for more vacation housing or more luxury homes. Rather, it's a need for more affordable housing and more workforce housing so we can support a more diverse community and have a workforce in place that can afford to live here. To apply this needs issue in this context seems absurd. The takings argument that was brought up by the applicant's attorney made what I would consider not so veiled threats about how would our city government like to face a takings claim. A takings claim occurs when the regulations deprive an owner of all economically beneficial use of their land. A smaller house than what you want is not a deprivation of all beneficial use. And in what world is what they're asking for a modest cabin, as was stated at one point? The applicant's attorney cited cases for you, but failed to fully explain what they stood for. For example, the Palazzolo case versus Rhode Island was completely misconstrued in the applicant's arguments. Is the applicant can still build a house on this property. It's just not the house that they envisioned or wanted, but they're not being deprived of all use of their property. The statement that no house under 2,000 square feet has been built in the community in the last several years, I have no idea where that, it's just not based in fact. My own house is under 2,000 square feet and it was built within the last 10 years. So I have no idea where those kinds of figures are coming from. One of the things that I find concerning, and I agree with Joe, is how did this even get as far as it did? I mean, it's not just the oceanfront setback, and I know that that's not an issue that is before us right now.
Issue for another time. I think that has to do with us as a body having language that protects us. I so don't want to go down that path tonight. I think we have so many different rabbit holes we could go into on this and so many discussions. I feel it's important to stick to things that are going to have us to a decision we agree on. And I don't mean that with any disrespect, and I do think we need to come back to it. I don't think tonight is the night.
Okay, well, I think that has to be revisited then.
I agree.
The geological issue and the traffic safety issue, both of those could lead to very, very serious implications for the city, could lead to lawsuits for permitting those kind of a landslide or encouraging or permitting a traffic accident to happen, creating an unsafe condition. So I think those things need to be addressed at some point. But I agree with you that it really is about the oceanfront setback tonight, and that we should deny this application.
Yes, is there?
By denying this application tonight, all that really does is allow a cabin to be built or house to be built that's smaller, that follows the setback rules for the ocean fronts, right? Lisa?
And if that were the case, then they would have that right.
Well, I think we should incorporate, there was several really good letters or arguments that were made by both Mr. Rasmussen and Orca in several letters. The October 20th and November 5th, submitted by Mr. Rasmussen and Miller Nash, as well as comments by Orca dated October 20th and November 5th. And I think that in some way, I don't know how you do this, but the record should be left open to address those issues, or they should be brought forward at some point. because denying the application, I mean, I think I'm making a motion that we deny it. But if we're just denying it only on the oceanfront setback issue, that's fine. But I think those other things have to stay ripe.
Actually, Lisa, on page 15, if you wanted to talk about how a motion to deny would look or sound, under the conclusion, the staff's conclusion, we would say it's denied based on our staff's findings and conclusions. We wouldn't have to be specific about whether it was the street or the lot. We would just say we are in agreement with the conclusions that we have there if we are.
Except the staff didn't conclude that there was a safety issue on the road, and the staff didn't conclude that there was a geological hazard. So how do you?
I couldn't make any conclusion along those lines, given what's presented in front of us tonight, and I don't think that is the crux of the question anyway. I'm very curious about that also, Lisa, but I couldn't tell you it's an unsafe situation or it is a safe situation based on anything that's been presented. So again, I think it's a rabbit hole that we should stay away from because we're not qualified to address that. And nor does it come to a decision that can ultimately be resolved in some way.
Unless there's any evidence on the record that is credible to say that it is a safe condition and that and we have heard some, we've heard about the geology from both sides. I mean, you always end up making a decision based on the evidence before you. You don't have to be an engineer or a geologist or a traffic safety expert to make a determination that you don't think something is safe. That's not what we are. We're a planning commission. And so when we have evidence presented to us or testimony presented to us, we do have to make some kind of a decision at some point. I'm not saying it has to be tonight, but I'm saying that I don't want to foreclose those arguments in the future.
Bill, did I hear tonight that those issues would be addressed at later times in this process? That some of those issues, take for example, the driveway or the location of the driveway?
Those issues would be addressed for those other pieces of the development. So if the driveway came in, it would be subject to review for the things that apply to them. In terms of the geologic hazard and whether it applies to this house, it's either, you say you're concluding tonight, either it's met or it's not met. To the extent the Planning Commission believes the arguments from the Haystack Rock LLC about the geologic hazards, and you could base, make your final decision based on the findings and conclusions in the staff report and the geologic hazard argument as set forth in the letter from Haystack Rock dated, I believe Commissioner Kerr said October 28th and November 5th.
October 20th and resubmitted. It was resubmitted on the 29th. It was submitted on the 20th and resubmitted on the 29th, and then there's a November 5th one as well.
And Lisa, I'm just going through our staff's report. You're suggesting it does not address the geology adequately?
That's what I'm saying. It's not addressed adequately, and neither is the traffic issue addressed adequately.
Yeah. Yeah, I would like to at least speak to that because we did not do it. If you look at the, would be Exhibit C9, which is Development Permit 2004. We have not, really even considered the building permit yet. We haven't considered the right-of-way permit or the right-of-way for the road. A lot of these things like tree removal permits for the private and the road, those haven't been considered. So there's a lot of things you're mentioning like that play into a building permit, like the geology hazard report. Those haven't even been addressed because this was simply, we need at least as oceanfront setback survey to begin any of this process is where it stands. So at the very end of C9, you have 6 different conditions of approval for this development permit. And the one that we're here tonight as a appeal is simply number 2 of 6 different conditions that have to be met before we would approve this.
Okay, so then I'm making a motion that we deny the application based on condition number 2.
I second the motion.
Lisa, okay, so can I have someone read condition number 2, just so I understand what the motion is?
I don't have.
I can read that. Condition 2 of the development permit 2004 reads, prior to the issuance of a building permit, the applicant shall provide oceanfront setback survey confirming that all proposed structures conform to chapter 1742 50A6 or a setback reduction approval from the Cannon Beach Planning Commission under 1764, authorizing a setback reduction for the structures on the site.
The survey's been provided. So
It has.
the condition hasn't been met.
Right.
The next part of that condition would be they come for a setback reduction. So I don't know that aligns cleanly, Lisa.
Yeah, I agree with you. It doesn't. So I would say I move to deny the application based on the fact that the oceanfront setback has not been met. The oceanfront setback requirement has not been met.
Okay.
Except it has, hasn't it?
No.
No.
Well, what was all the business about only being able to build a matchbox on the lot if the city's calculations were accepted? I mean, we have evidence that the appellant has appealed based on that city decision, which addresses the oceanfront setback measurements.
So we're asking to deny the appeal.
Yes.
In other words, they're not meeting. It's my position that they have not. They are misconstruing the oceanfront setback regulations, and they are not in the current application does not meet them.
So they're still in process of trying to get their permit.
Commissioner Barron, they have applied for a particular house. That house does not meet the oceanfront setback as the city staff calculated. They appealed that decision. They're saying we comply with the oceanfront setback or the oceanfront setback doesn't apply. And so what I hear Commissioner Kerr saying is we want to affirm the city staff's decision on the oceanfront setback and deny the applicant because the house as proposed does not meet our oceanfront setback.
Okay.
We're denying the appeal.
Bill, just quickly, just be very careful here. We had a motion, it was seconded. Do we need to go back in time at all and address that, or can we move on to a new motion?
I think if there's a motion that has been made and seconded, you've got to resolve that motion unless it's a motion that takes precedence. And so, I think if in fact the commission's ready to make a decision on that motion, that is probably the way to proceed.
I'm just asking procedurally. I'm not ready to, I was not ready to make I asked for clarification on that because I wasn't understanding what the motion was, but I did hear Barbara's second. I just want to make procedurally sure we are being as tight as we can in terms of our actions. So if we need to go back and vote on it, we can, or if you're saying, hey, you need to be ready to vote, I'm not ready to vote.
Yeah, so as I understand it, a motion was made, it was seconded, and you're in the discussion phase of talking about whether, whether or not to approve the motion.
Okay, so we can have a discussion after a second is made. Thank you for the clarification.
Okay, is there any further discussion on this motion?
Can we read the motion one more time, what it is most recently?
Well, I don't have it written down in front of me. I moved to deny the application, deny the appeal based on the fact that this application does not comport with the oceanfront setback as required by law.
Bill, would that be for 3 proposals or just one? We have 3 different. We have
Yeah,
appeals here.
it was termed in terms of one, and maybe just a point of order to clarify that you're intending to deny all 3 applications, one based, the one based on the actual substance of the oceanfront setback, and the other 2 to dismiss is not properly filed.
Okay.
Okay, any further discussion by the commissioners?
Could we have the administrative assistant read the motion?
But with those changes Bill made.
With the changes Bill made, so Kerr moves to deny it based on the oceanfront setback, and then as Bill stated, there's 3 motions that will deny the appeal for one. The other 2 are denied because they were improperly filed.
Thank you.
Okay.
I'll second that.
Okay. Any further discussion? Okay, let's call the roll.
Commissioner Burt?
I couldn't hear you.
Joe?
Burt?
Are you trying to reach me?
Yes, Joe.
Yes.
Yes, I support the motion.
Commissioner Bennett?
Yes.
Commissioner Kerr?
Yes.
Commissioner Knopf?
Yes.
Commissioner Newton?
Yes.
Chair Johnson?
Yes. Okay. Motion passes. Okay, do I have a motion for the chairman to sign the appropriate orders?
So moved.
Second.
Call the roll.
Commissioner Bennett?
Yes.
Commissioner Kerr?
Yes.
Commissioner Knopf?
Yes.
Commissioner Newton?
Yes.
Commissioner Burt?
Yes.
Chair Johnson?
Yes. Okay. You all have the tree report, ongoing planning items?
We will look at schedule those dates with the joint for January. That's still on schedule from as far as I know, or the last I've heard, even though I know the school is out there as another big project. From my understanding, they're still keeping that on their upcoming agendas. And so I'll let you guys know as soon as I have any kind of dates thrown out there for that.
Okay.
And are we going to address the changes in the ordinances at the next meeting, like square foot oceanfront height limit I'd like to address?
Yes, Lisa, that is on for the next agenda, and that is posted. All that is posted with the staff report on the website for that meeting. I'll send that link around to everyone just to remind them, but that's been sent out. We sent out notice for that as well. And so that'll be December 22nd, I believe, is the date on that for that meeting.
Jeff?
Yes.
Could I add one more issue on there for discussion?
Sure.
Well, I'd like to discuss oceanfront height limit of homes. I'd like to open that discussion at that meeting as well.
Okay, and let's see, was there anything else that, oh, yes, and Bill will be at Luba on December 1st with the Fordham Management appeal.
Is there any way we can attend that by Zoom as an audience?
They do not do things by Zoom. It's telephonic. And if you want, we can make that telephone number available to you. I will tell you that Luba is not the most sophisticated technically. And I think, that may have more to do with budget than their desire to be more sophisticated, but it's essentially an open telephone line. And so it's an interesting experience arguing at Luba with people listening in. So I think Jeff already has that telephone number. If you want, we can make sure we get it to you.
Yeah, I can do that. And before we sign off, I first want to say thank you to the Planning Commission for how you guys have responded in this COVID situation with this kind of meeting set up. Also to the applicants and all parties that have been part of this. It's not been the easiest to get everything and trying to get the record together and out there, but I appreciate everyone's patience and working with staff on that.
Okay, is there anything for good of the order? Okay, in that case, we are adjourned. Thank you all.
Not everyone.
Night.
Thank you.
Thank you.